How is everyone doing today? Welcome back to another episode of The Banker Next Door. I'm your host, Dr. Joe Berquist. Today, we're going to be taking a look at an article from Bank Director around failed Kansas bank, Heartland Tri-State Bank. If everyone recalls, I did an episode of the crypto series a number of months back where I detailed kind of the whole story here. It was kind of a wild story. The CEO and embezzled $47 million from the bank. And he did that because he got caught in a crypto scheme, kind of similar to like what they call pig butchering. And so now we've had this whole court case unfold where the judge in the case just made a kind of a wild and unprecedented ruling. So I want to get in. I wanted to bring this case to everybody. And this was kind of hot off the press from basically like this weekend. So this article is titled "Failed Banks Shareholders Win Big in Crypto Embezzlement Case." In an unusual decision, a judge awarded Heartland Tri-State Bank shareholders all money recovered in an FBI operation, and the FDIC got nothing, which is wild. So when tiny Heartland Tri-State Bank in Elkhart, Kansas failed in 2023, shareholders appeared to have lost everything. Now, in a stunning development, they've recovered the lion's share of their investment bank, the Federal Deposit Insurance Corp, which typically comes out ahead of shareholders in the distribution of failed bank assets, came up empty-handed. So Heartland Tri-State collapsed in July of 2023 after their CEO, Shane Haynes, embezzled $47.1 million over 6 weeks to cover personal losses suffered in a crypto scam that federal investigators say originated in Southeast Asia. The failure roiled Elkhart, a remote farming town of 1,900 in southwest Kansas, but was especially devastating for 33 local shareholders, a collection of farmers, teachers, former bank employees, and community leaders who saw about $13 million in capital on the $139 million bank's books abruptly vanish. So late in 2024, the FBI found $8.1 million of the embezzled funds in a Tether account that was never delivered to the crypto scammers. A federal district court judge in Wichita, Kansas, subsequently awarded the shareholders of Elkhart Financial Corp., the bank's holding company, all of that money. In August, after months of uncertainty, the shareholders got their payoff. So now they're calling this a feel-good story. So it's a feel-good story for a town that lost its only bank and took a heavy financial blow after being betrayed by a trusted local leader. Haynes was found guilty in a criminal trial and is now doing time at the Federal Correctional Institute in Leavenworth, Kansas, scheduled for release in 2044. Shareholders, many of whom counted the bank as a core investment holding, initially saw their finances devastated by the failure. Some were forced to sell their homes or change retirement plans and elderly care arrangements. A few suffered health problems. The effects rippled through the community. The jubilation following the judge's November 2024 restitution award was replaced by angst as procedural hurdles delayed the money's release. Some worried that the decision would be appealed or overturned. There were testy conversations with court officials, Zoom calls with the Department of Justice, and lots of confusion and frustration. I feel we have been and are being further victimized by the process, former board member and shareholder Jim Tucker wrote in a June text. On a mid-August weekend, the payments finally arrived. The amounts ranging from about $3,000 to more than $700,000, depending on ownership stakes, were roughly equal to the cost basis of shareholders' initial investments when the holding company started in 2011. It was quite a ride all the way to the end. Tucker, who declined an interview request, texted in September. The FDIC gets shut out. Some legal experts wonder how the FDIC, which is required by law to minimize losses to the industry-funded Deposit Insurance Fund, lost out to shareholders who, in theory, are supposed to be the last on the recovery totem pole when a bank or any company goes bust. Shareholders of the three regional banks that failed in 2023, including Santa Clara, California-based Silicon Valley Bank, received nothing in the aftermath of their 2023 failures. It's unusual to see shareholders get something back, but much about this failure is unusual, says John Geringer, a partner with the Barak Farzano, Kirschbaum, and Nagelberg law firm in Chicago, who was not involved in the case. History suggested the agency would get its way. A memorandum of understanding with the Department of Justice signed in 2007 states that under banking law, the agency is entitled to receive all restitution due to that institution resulting from the conviction of crimes committed. against a bank for which it is a receiver. Importantly, the MOU states that as a receiver legally stepping into the bank's shoes, the agency should be considered a victim and not the United States in restitution cases, which elevates its standing on the priority list. Attorneys say the MOU was likely meant to encourage a judge to use banking statutes which favor the agency instead of criminal statutes. I don't think you would likely see the same decision by a court that has more familiarity with the FDIC and its role, said Brendan Clegg, a partner with Luz Gorman in Washington, D.C. So the judge's rationale. In this case, the FDIC did something attorneys say is relatively rare, acknowledging that the shareholders also were victims and asserted in filings that it was entitled to a pro rata share of the proceeds. The agency's $47.1 million loss was 85% of the $55.5 million in losses claimed by the agency and shareholders combined in a plea agreement. The FDIC proposed that it received 85% of the found money, or $6.86 million, while shareholders divided the remaining $1.21 million. U.S. District Court Judge John Brooms, who had listened to anguished victim testimony through the trial and sentencing hearing, didn't follow the suggestion or accept the MOU. Citing federal criminal statutes, he ruled that the agency was the United States, which puts it in lower on the priority list than individuals. If the FDIC is an agency, then it is the United States for purposes of restitution, he explained. According to transcripts from the restitution hearing, with that interpretation, under U.S. Criminal Code, I am instructed to pay the shareholder victims before I pay the FDIC, he added. While conceding that this rationale might be wrong, Brooms noted that in part because the FDIC acknowledged multiple victims, he also was entitled to use my discretion to create a payment schedule based on individual victim circumstances. There might be circumstances where the shareholders of a failed institution are wealthy operations, investment funds, Wall Street institutions dripping with money, he said, which could merit putting the government on more equal footing with shareholders. In this case, the evidence is clear that this was a local banking operation funded by members of the community who, to varying degrees, invested a substantial part of their life savings in this operation and lost a lot of that as a result of the crimes committed by the defendant in this case, Brooms said. Their economic circumstances as a class, to me, justifies seeing that they're paid first. So the FDIC is still entitled to restitution of $47.1 million, the judge added, but only after the other victims have been paid. So the reaction. So does Brooms' ruling mean anything for other failed bank resolutions, or is it merely a one-off driven by unusual circumstances? Regulatory attorneys interviewed for this story cannot recall another instance where assets were available after a failure and the FDIC didn't prevail. Some questions the agencies acknowledge of multiple victims. Once you admit there's more than one party, you leave yourself open to what happened here, says one attorney who asked not to be identified. Others think it's odd that the agency didn't appeal the ruling. Clegg, who was not involved in the case, speculates that because the dollar amounts were relatively small, the agency might have concluded that it wasn't worth the risk of setting a new precedent. While another judge could still cite Brooms' ruling as persuasive, precedents are set at the appellate court level. If the appellate court rules against you, it could affect more significant cases down the road, he says. It's also possible, attorneys say, that with the CEO already in prison, a big federal agency decided it wasn't worth challenging a group of sympathetic farmers in the present political climate. For the time being, everyone seems content to let the matter rest. The FDIC would not comment on the record for this story, and the U.S. Attorney's Office in Wichita, which represented the agency in court, declined to comment. Shareholders, too, have gone quiet. They got what they wanted and don't want to risk somehow losing it. That doesn't necessarily mean the board members, all of whom own shares, are out of the woods. The FDIC has been known to sue directors up to 5 years after a failure if it finds evidence of negligence, poor controls, or lacks oversight. It wouldn't surprise me if they at least looked at that angle, Clegg says, so former directors might be celebrating now, but the waiting could continue. So, again, very, very interesting case here with this Heartland Tri-State Bank. I have a tendency to agree with the judge here. I think the judge made a very astute ruling here, a very unusual ruling, but nonetheless, I think very astute. I think he correctly read the situation and basically said, you know what, this isn't some mega bank or some large regional bank. This is a small little bank in Kansas. This bank was a pillar of the community, and many people in the community had invested a lot of money to bring this bank up. It was their only bank. It was the only bank in this area. And when this bank went down, a lot of these people lost. I mean, some of these people lost everything. I mean, they had to sell farms and houses and businesses. I mean, it was a horrible, horrible situation. And the amount of betrayal on the part of Shane Haynes, the CEO, who, basically, grew up in this community and was beloved and trusted by the people in this community. I mean, for him to betray them in the fashion that he did because he got caught up in this crypto scheme is just, it's horrifying. So I think this is great. I think it's great for the shareholders there. Could the FDIC sue some of these shareholders for negligence or lax controls and oversight or whatever? They could. I don't think they will at the end of the day. I think they're going to let this one go. I think they're going to, these people got their victory. They got a little bit of money back. This is not, the FDIC getting a few $1 million back on this one isn't going to change anything. I mean, they took a, 40 something $1 million loss. I mean, it kind of is what it is. It's not going to harm the FDIC insurance fund. It's not going to cripple anything. It's not going to have any major ramifications. So I think ultimately they'll probably just let this one lie, even though I mean, again, there's always, and I think it's particularly in this case, you could make an argument that some of the board of directors were lax and didn't do what they were supposed to do, or maybe didn't give Shane, the CEO, the amount of oversight that he should have had, But anyway, like I said, I think it's a feel-good story. I think it's a good verdict for the shareholders here. I don't think the FDIC is gonna appeal this, or is gonna try to sue any of these shareholders down the road. I think they're just gonna let this one go, and I think these people are happy to just kind of get back to their lives. So, okay, with that being said, I hope you guys liked the episode 29 of the crypto series. Stay tuned for tomorrow. I will have episode 30 of the crypto series coming out, where I will give a full crypto update on just kind of a whole bunch of stuff going on. So make sure to come back and check that out. And please make sure, if you haven't checked out any of the other episodes in the crypto series, check them out, because this series is a kind of a wild ride of everything nutty and amazing in the world of crypto. So, but with that being said, I will remind everybody to please make sure to like, share, and subscribe. That always helps the channel. Remember, we are on YouTube, Rumble, and all major podcast platforms. Please be sure to leave your comments down below, as I always love getting back to everybody. And as always, make sure to check out some of the other content on the channel. I thank you so much for listening. Have a great day out there, and I will see everyone again real soon.